goal of this training is to provide a general overview of the civil rights requirements that state and local agencies should know for administering their programs. This training is based on a presentation by the Civil Rights Division, USDA Food and Nutrition Service in 2021, and more recent instructions and policies. These are some of the common abbreviations that will be used throughout the presentation. Many of them are probably familiar to you, but just take a few minutes to look at the slide and see if there's any that surprise you. As we talk today, we'll be covering this agenda. First of all, we'll talk about what discrimination is and how it's defined. We'll look at the coverage areas of civil rights and legal authorities that define it. And we'll cover the civil rights topics, civil rights assurances, public notification requirements, racial and ethnic data collection, how to handle a complaint of discrimination, how to complete a civil rights training, information about limited English proficiency and what that is, disability compliance, compliance reviews, how to handle resolution of non-compliance, and then we'll also cover some conflict resolution and customer service techniques. What is discrimination? Discrimination is different treatment, which makes a distinction of one person or a group of persons from others. It's either intentionally, by neglect, or by the actions or lack of actions based on a protected class. There are 6 protected classes in Food and Nutrition Service child nutrition programs. They include race, color, national origin, age, sex, and disability. Schools and institutions receiving federal funds must follow civil rights regulations and policies. These regulations direct sponsors on the proper procedures to follow so that benefits of child nutrition programs are made available to all eligible persons in a non-discriminatory manner. All sponsors receiving federal money must implement civil rights requirements to be eligible for all child nutrition programs. The Food and Nutrition Service Instruction 113-1 is the federal regulation governing civil rights in child nutrition programs. This slide represents child nutrition programs and food distribution programs and their code of federal regulations that fall under the FNS 113-1. There are specific laws that have established the protected classes. Title VI Civil Rights Act of 1964 prohibits discrimination based on race, color, and national origin. The scope of civil rights was further clarified in 1987. Section 504 of the Rehabilitation Act of 1973 prohibits discrimination based on disability. The American with Disabilities Act of 1990 prohibits discrimination based on disability in all services, programs, and activities provided to the public by state and local governments. The Act of 2008 further defined what qualifies as a disability. Title IX of the Education Amendments Act of 1972 prohibits discrimination based on sex under any education program or activity that is receiving federal financial assistance. And finally, the Age Discrimination Act of 1975 prohibits discrimination based on age. To qualify for federal financial assistance, an application must be accompanied by written assurance. The written assurance states that the program or facility receiving financial assistance will be operated in compliance with all non-discrimination laws, regulations, instructions, policies, and guidelines. A civil rights assurance statement must be incorporated into all agreements between federal and state agencies and local agencies or sponsors, and local agencies and subrecipients as applicable. Retailer and vendor agreements must also include an assurance of non-discrimination. All food and nutrition service assistance programs must also include public notification. The purpose of this system is to inform applicants, participants, and potentially eligible persons of program availability and the steps necessary to participate, program rights and responsibilities, the policy of non-discrimination, and the procedure for filing a complaint. Furthermore, with respect to public notification, state agencies, local agencies, sponsors, and subrecipients must make program information available to the public upon request. They need to prominently display the End Justice for All poster. They need to inform potentially eligible persons, applicants, participants, and grassroots organizations of programs or changes in programs. Convey the message of equal opportunity in all photos and other graphics that are used to provide program or program-related information. And provide appropriate information in alternate formats for persons with disabilities and the appropriate language for those who have limited English proficiency. Non-discrimination statement is a key part of public notification. At a minimum, the full non-discrimination statement should be included on application forms, notification of eligibility or ineligibility, notice of any adverse actions, including an expiration of certification notification and a discontinuance. The non-discrimination statement also needs to be included on the program home web page, or it needs to be one click away. And it should be included on public information materials, including the media. If you send menus home, the non-discrimination statement does not need to be included on that. Use of our Child and Adult Nutrition Service Department of Education prototypes assures that the non-discrimination statement is on everything it needs to be on. If you are using a computer-developed prototype, be sure that the statement is included. Work with your software company to get it updated if needed. And if you notice that the statement is missing from documents, please contact our office for clarification, and we can help you with that. The non-discrimination statement should be used as it is. Please don't move it into a paragraph format. That is probably one of the most common things that we see. If the material is too small to permit the full statement to be included, the material will at a minimum include the statement and print size no smaller than the text of the document that says this institution is an equal opportunity provider. The non-discrimination statement can be found in 21 non-English languages at the website listed, and that's the clickable link that you can use at a later time. This is the End Justice for All poster. Program participants should be able to see the End Justice for All poster. Please put it in a place where everyone has access to it. AD 457A is the green poster that's pictured, and that's the most current version. If you need a new poster, please contact the CANS office and we can get one for you. Keep in mind that local reproduction of this is not authorized. The document itself contains a non-discrimination statement and provides program participants the information necessary to file a complaint if needed. Race and ethnicity data collection is also required. This data assists with monitoring civil rights compliance and can identify potentially eligible participants who may not have been previously reached by program services. And it's mostly used to complete reports as required. Race and ethnicity data needs to be collected and kept for 3 years. Agencies are required to inform participants that data collection is voluntary and information that is provided is only being used for federal civil rights compliance. It does not change program eligibility or their right to participate in services. If an applicant does not consent to the self-identification method, the individual taking the application will, through visual observation, determine the applicant's race or ethnicity and mark the appropriate category. Please remember that children are not to be surveyed. The purpose of collection is to meet federal regulations and compare your participant data with potentially eligible persons. Racial and ethnic information should always use a 2-question format, with ethnicity being listed first. And this is an example of the 2-question format. And you'll note that there also needs to be the option of more than one race to be selected.
Next, we'll discuss complaints of discrimination. A civil rights complaint is a verbal or written allegation of discrimination that Food and Nutrition Services program is administered or operated in a manner that results in different treatment or services being provided to persons or group of persons because of a protected class. As all civil rights complaints shall be accepted and forwarded to the Office of the Assistant Secretary for Civil Rights. The complainant must file a complaint within 180 days of the alleged act of discrimination. Complaints may be written, verbal, or anonymous. State agencies or local agencies may develop their own complaints form, but the use of such forms cannot be a prerequisite for acceptance of a complaint, as the use of the complaint form is not required. Confidentiality is extremely important and must be maintained. There is a USDA complaint form that is available for persons to complete. There's an English version and a Spanish version. We have links listed on this slide right now. Specific areas of information that will need to be shared for civil rights complaints to be filed, such as name, address, telephone number, and other means of contacting the person alleging discrimination. The location and name of the organization or office that is accused of the discriminatory practices, and the nature of the incident or action or the aspect of the program administration that led the person to allege discrimination, which includes information like the date and of the incident and the persons involved. All staff who work with child nutrition programs must receive training on all aspects of civil rights compliance annually. New employees should be trained on civil rights requirements before participating in program activities or within 30 days of hiring. Volunteers must receive training appropriate to their roles and responsibilities. Here's a list of the subject matter that the annual civil rights training must address. Training records need to be kept on file. Training records include the agenda, sign-in of the staff who received the civil rights training, and presentation, if applicable. Limited English proficiency. LEP, or limited English proficiency, refers to individuals who do not speak English as their primary language or who have a limited ability to read, speak, write, or understand English. Local agencies have a responsibility to ensure persons with LEP have meaningful access to their services. Failure to provide meaningful access to persons with LEP could result in discrimination on the basis of national origin. What is meaningful access? Meaningful access is providing reasonable, timely, appropriate, and competent language services at no cost to individuals with limited English proficiency. This is what meaningful access looks like at the local level. Applications and participants cannot be asked to bring their own interpreters. Children should not be used as interpreters. Use qualified, competent language resources at no cost to the participants. Consider using bilingual staff or interpreter services as needed. LEP population and data sources. Community demographics change over time. Here's a list of a few data sources that can be used to document a need for LEP services and materials. Okay. Reasonable modifications are to be made for participants with disabilities. A public entity shall make reasonable modifications in policies, practices, or procedure when the modifications are necessary to avoid discrimination on the basis of disability, unless the public entity can demonstrate that making modifications would fundamentally alter the nature of the service, program, or activity. A disability is defined as any person who has a physical or mental impairment which substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. To constitute a disability, a condition must substantially limit a major life activity. A major life activity means functions such as caring for oneself, performing manual tasks, walking, talking, seeing, hearing, speaking, eating, breathing, or learning and working. The Americans with Disabilities Act impacts the National School Lunch Program, the School Breakfast Program, Special Milk Program, Child and Adult Care Food Program, and Summer Food Service Program as it expands the definition of disability. Major life activities include functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, cardiovascular, endocrine, and reproductive functions per the ADA Amendments Act of 2008. Individuals who take mitigating measures to improve or control any of the conditions recognized as a disability are still considered to have a disability and require an accommodation. What does program access and reasonable accommodation mean for those individuals with a disability? Services shall be provided in the most integrated setting appropriate to the needs of the disabled individual. The school/agency is responsible for assisting students and children with the disabilities where assistance is needed. Okay. Federal regulations that govern diet modifications in child nutrition programs require sponsors to provide modifications to the standard meal for participants who are considered disabled or whose disability restricts their diets. Each recipient shall serve modified meals at no extra charge to participants whose disability restricts their diet. Child nutrition programs are required to modify meals when a participant has a major life activity that is impacted. A signed statement from a recognized medical authority is required when the modification requires deviation from the meal pattern. This may include a doctor, nurse practitioner, or physician's assistant. Federal regulations permit modifications for other participants who are not disabled, but this is not required. Compliance reviews. Civil rights compliance reviews examine the activities of state and local entities who receive federal funding. Significant findings must be provided in writing to the reviewed entity and to the USDA Food Nutrition Service. There are three types of compliance reviews for civil rights. Pre-awards are conducted by the state agency as part of the agency's initial application to assure that an institution is in compliance with Title VI. Routine post-award reviews are completed on an ongoing basis and may include questions such as, do printed materials contain the non-discrimination statement? Is the "And Justice for All" poster displayed prominently and appropriately? Are program information materials available to all? Is data on race and ethnicity collected appropriately? How are applicants and participants advised of their rights to file a civil rights complaint of discrimination? Are reasonable modifications appropriately made for people with disabilities? Is everyone at the agency trained in civil rights procedures? Special reviews occur by the USDA Office of the Assistant Secretary and/or Food Nutrition Service if there are issues that impact the delivery of services of benefits, such as reports of civil rights compliance by an agency, patterns of discrimination complaints, or statistical data that shows underrepresented minority groups in a program based on those who are potentially eligible for benefits. Compliance is a factual finding that any civil rights requirement as provided by federal and state law, regulation, policy, instruction, or guidelines is not being adhered to. There are no minor or major categories of noncompliance. No matter the level of severity, noncompliance must be reported. Some examples of noncompliance include denying an individual or household the opportunity to apply for program benefits or services, providing services in a dissimilar manner, selecting program sites or facilities in a manner that denies an individual with access to the program benefits, assistance, or services based on a protected class. Conflict resolution and customer service techniques should be incorporated annually into civil rights training for frontline staff. Issues that arise can often be resolved before it leads to a civil rights complaint. This concludes the civil rights training. So you can feel free to contact us with any questions after the webinar through our office line or through our email. Just for record keeping purposes, we have the time for the training today, and we'll be taking some questions shortly. And we're going to drop in the evaluation link into the chat as well here. So if you can follow the link